In the Idaho 4 Brian Kohberger case, we've all, of course, heard about Brett Payne. He was the Moscow Police Department official who wrote the probable cause affidavit, or at least the exhibit attached to it. But what about Lawrence Mowry? Whatever happened to him? It's all hush-hush.
Lawrence Mallory? That name strikes a bell. I'm Lainey Law.
And I'm attorney Andrew Myers.
And Andrew, what are we talking about today?
Well, there are all kinds of motions, as you know. One day you came in and I was scratching my head because I think 12 or 14 motions had just been filed that day. There are a whole pile of motions to suppress evidence, which will be or may already have been adjudicated by the time people get to watch this episode. But the whole veil of secrecy continues. Remember back when the case went from Moscow, Idaho, and the venue was changed and they sent it down to Boise, and people, including me, thought that the case would open up a little bit more?
Mm-hmm.
Well, we were all wrong. So let's take a look at one of the affidavits or one of the motions that was attached to all of those motions. This is a stipulated motion to seal the state's amended expert disclosure regarding Lawrence Mowry. Who is Lawrence Mowry, you ask? Well, he was one of the top detectives working on the case. And again, this is the state, but it was also stipulated by the defense. Come now, the state of Idaho, by and through the Latah County prosecuting attorney, and hereby moves the court pursuant to Idaho Court Administrative Rule 32G1 and Idaho Code Section 74124 for an order sealing the state's amended expert disclosure regarding Lawrence Mowry. Does that sound familiar? They're sealing something in the case?
Does that sound familiar? They're sealing something in this case. This entire case is a series of being sealed, if we're being honest.
And all attached exhibits herein because release or disclosure would 1. Interfere with enforcement proceedings. 2. Deprive a person of a right to a fair trial or an impartial adjudication. 2. Wait a minute. Even a baby knows it's 1, 2, 3. It's not 1, 2, 2. If a little child said 1, 2, 2, wouldn't you correct him?
That's just the typo that they just left in there. That's it. Can't be. Is there a chance that it's the same point somehow?
We are not being picayune. Going way back to January of 2023, this nomenclature was used in a motion. It's been repeated over and over and over in cut and paste manner, such that they're not even thinking about the secrecy matter anymore. They just cut and paste this. Mm-hmm. There are 5 reasons, 1, 2, 2, 3, and 4. And they just cut and paste this in motion after motion after motion. So this privacy and secrecy is not even a matter they think about anymore. They just cut and paste it. And you would have thought that they corrected it. And we've made a point of this before. Are we being picayune? No, because we mentioned this before and others have mentioned it too. And they just keep talking. Remember we talked about this one time when we pointed out that in the motions, motion after motion, it says the 4th reason, nomenclature number 3, disclose the identity of a confidential source. Mm-hmm. And number 5 or number 4 here, disclose investigative techniques and procedures. So in any event, it's a standard motion that they've brought many, many, many times. They just put a new heading and a new bottom on it. But you would think at some point somebody would have read it. The undersigned has contacted the defense, and they have no objection to this motion. The state respectfully requests that this is a little legal point. Okay, say I'm being picky on stipulated and no objection are 2 different things, really. If I'm about ready to file a motion and you're on the other side, I call you on the phone, and you can say one of 2 things. Andrew, I have no objection. Or I'll stipulate to it. Stipulate means you agree, and the court can just go ahead and approve it. So the bottom line is the same, but they are 2 different things. If you have no objection to my motion or if you stipulate to it, I'm sorry, but they are, 2 different things. The state respectfully requests that the court seal from public disclosure the state's amended expert disclosure regarding Lawrence, Lawarence, Lawrence Mowry,
Mhm.
and all attached exhibits herein under the provisions of Idaho Court Administrative Rule 32G1 and I2E and Idaho Code 74-124. And it's signed by Ashley Hush Jennings, the senior deputy prosecuting attorney. So what could be in all of those exhibits? Well, we're going to take a look at a newspaper article in a minute that kind of takes us back to a hearing that was held in May of 2024. But Lawrence Mowry is a forensics guy. He goes into the technical things. He was the one that was looking at the cell towers that were pinging, but he was up to some other things too, which we're going to dig into in a minute.
It's just so weird looking at these documents, like with the 1, 2, 2, 3, and 4, or the Lawrence at the end. It's reminding me of my homework when it's due the next day, and I'm staying up until 1 a.m. doing it. It's a lot of tiny little easy to spot typos going on there.
Proofreading. But then
also when you're writing something in Word, I feel like the 1, 2, 2, like 3, 4 is something like Word would have caught, or even the Lawrence, I don't think it would have let fly. So that was very interesting.
Well, I write stuff in a hurry, and sometimes before I've had my second cup of coffee, or at the end of the day when I'm getting tired. But a paralegal goes over it all, and she doesn't even redline it anymore. She just corrects it. So, yeah, there were 24 corrections. That's fine. We're human. We're human beings. You know, whether you're an attorney in a law office, and I would expect that the state of Idaho has enough people that a paralegal can, review this stuff, or whether you're working at a newspaper and you have an editor, stuff doesn't get in the newspaper or online of a better news outlet until, the reporter is under deadline and bangs it all out. But then there's an editor. That's why they have editors. But anyhow, I digress. So let's go on to the newspaper article that I told you about that will remind you of who Mr. Mowry is. And this goes back to May 2024. Moscow police officer testifies in University of Idaho M case. And this is an article that came out of KXLY TV. Apparently, when they have like most TV stations now, they'll not only have the news on directly on TV, but they'll print something out and put it online. A Moscow police detective testified in the University of Idaho M case Thursday as part of the defense's motions to compel the state to hand over certain evidence. The evidence at stake involved the cell phone data the night of the M's, critical information referenced in the affidavit of probable cause, which the defense has yet to receive. It was the first time a member of the Moscow Police Department has taken the stand in this case. Detective Lawrence Mowry testified his role in the investigation was to collect digital information related to the case. Detective Mowry is considered a digital forensic specialist, having previously been recognized by the U.S. Secret Service for his achievements in the field. Okay. The defense's goal was to better understand how the state tracked Kohberger's cell phone the night of the M's and to have that evidence turned over for them to review. In April, again, this is 2024, Kohberger's legal team said their client was driving south of Pullman, Washington during the time of the crime on November 13th, 2022. I'm not sure if that's totally accurate, whether he was driving south of Pullman or whether he was already at Wawaki Park. Defense attorney Ann Taylor began her line of questioning, asking about different pieces of evidence in which Detective Mowry looked at. Taylor asked about the call detail records Mowry was asked by the state to obtain on the night of the murders. Mowry said he took the CDRs from Kohberger's cell phone from the night of the M's and dropped them into the CAST, a computer software that breaks digital records into more detailed information, including location and cell phone towers. Remember, we went pretty much into detail way back then. Remember that? Mm-hmm. So he revealed that after he sent the state the data from CAST. He did not save the files on his computer, though he assured the court he could replicate the data. So he did all these testing, which, no juror really, unless is a forensics engineer on the jury, no average person like me is going to understand all this stuff. So after he did all these tests, he didn't save it.
That to me is crazy, the not saving it part.
He ditched it.
Yeah. Well, and obviously people make mistakes. We're all human. But I was just thinking about the last document we were reading and all the typos on that. And I was thinking about, for my stuff, if you're programming, you can't even get the program to work if you have a typo. So not only that, and then reading this, and it's just like, oh, he got all the data, but then he didn't save it. What was the point of getting all the data? What are you doing? Do your job.
and as a scientist or as a detective who is going to need to explain to the jury, you've got to be able to show your work. You've got to be able to show how you got to that conclusion. That's a pretty firm concept in the law, that if you have an expert on the stand, a forensics expert or any other kind of an expert, they can't just state an opinion, because the follow-up question is, on what do you base that opinion? And they're going to have to substantiate that. And so, would you agree I can't see what you did without your session log? And Taylor asked. You cannot, Mowry admitted. But I can take those cell phone call records, put them into CAST. Again, the results would be what they are because we're still using the same records from AT&T. All right. A grand jury indicted Mr. Kohberger in May 2023 from information gathered on these CDR files. That's why this is so important. We're not just making a big deal out of this. If you're going to, as a prosecutor, try to put somebody before the firing squad, which is what they're trying to do, or otherwise enforce the capital punishment, you've got to dot your I's and cross your T's. It's not just some guy sitting in a podcast saying, oh, well, yeah. No, you've got to cross your T's and dot your I's. So this just goes on with a lot of background, which I think a lot of us understand. But it just seems that, among many questionable things, I'll say, that happened during these investigations, that's one of them. So
it does make sense.
So Mowry is up to some other things. Among the many motions to suppress, which we've kind of gone over these in a previous episode, but one of the ones that we really didn't do a deep dive into in the past was a motion with regard to cell data. And here it is. Motion to suppress cell phone USB file and memorandum in support. This is the defense's motion regarding the Moscow Police Forensics Lab. This is what ties into Mr. Mowry. And this goes back to a warrant that was dated on January 9th. And we're not going to read the whole thing. We're just going to try and zero in on what's important here. Comes now, Brian.
Terabytes and getting scared.
Oh, no, we're not doing the terabytes and the gigabytes. Oh, please. We got so many comments about that.
Oh, that's crazy. That's why, they say it's like when you're working and you have a nightmare dream, like you go to sleep and you're just dreaming about work. That would be sorting through these the information on the terabytes. That's what it sounds like to me from hell.
Well, just as a little bit of a preview of what this particular motion is all about, if you're a police officer, you know that you have to comply with, the Constitution of the United States and the Constitution of your own state, in this case being Idaho. And when you're doing a search warrant, you've got to be reasonably specific. And here's an example of that. You can't just, say, well, let's go into the house and get everything. Comes now Brian Kohberger by and through his attorneys of record and submits the following memorandum in support of his contemporaneously filed motion for an order suppressing all data found by law enforcement from its search of the Seagate 2 terabyte external USB drive with serial number XYZ. I didn't know this is the same as a thumb drive, right? That's what.
Yeah, that's what they're talking about.
Yeah, but I didn't know they held 2 terabytes. Do they hold 2?
Oh, they make some big
really?
ones. Yeah.
Wow, I didn't know that. Because most of the ones that I use in my law practice are smaller than that. Like I mailed out a package that would have been like this big to an insurance company yesterday, but it was on a thumb drive. But that's all paper. So you don't really need I don't know, but it wasn't even 1 terabyte. Anyhow.
Yeah, they're pretty big, these ones. Okay, so I just looked it up because they are pretty big portable things. So this is, it connects to your USB, but it's not like a classic like thumb drive type thing. It seems to be more of a little bit of a brick. So they're a little bit thicker.
Okay,
so
you
that's how they
corrected
can
me.
fit more space.
I have one at home. I didn't realize that's what they're talking. It's about yay big.
Yeah, I think that might be similar to what they're talking about.
So we're not talking about a thumb drive.
It's similar.
Are talking about and it says that right there, an external USB drive. Okay. All right. Yeah, mine has 2 terabytes on it, I believe. I think. The motion and documents in support of Frank's hearing are hereby incorporated into this memorandum. The proper I wonder how many people are going to say, "Ha ha, you didn't know that."
Oh my God, I don't want to hear it. You don't know the Seagate?
As opposed to the people that don't even know the difference, like I obviously didn't until you explained it. The motion and documents in support of Frank's hearing are hereby incorporated into this memorandum. The proffer with supportive documentation regarding Frank's are filed under seal. For that reason, they are not set forth in the full detail here, but instead are incorporated. Issues. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. 2. The affidavit submitted in support of the application for the issued search warrant included information that must be excised. All information in the affidavit was gathered because of law enforcement's unconstitutional use of investigative genetic genealogy, and thus nothing in the warrant should remain. Information gathered about Mr. Kohberger via previous invalid warrants must also be excised. The search warrant fails to command law enforcement to search the USB drive. So this is where it gets good. Pennsylvania law enforcement, along with officers from Idaho and the FBI, raided Mr. Kohberger's home on December 30th of 2022. We all know that. During the raid, law enforcement seized Mr. Kohberger's cell phone. After seizing the phone, FBI SSA agent Jeffrey Tanzola made a copy of the contents on the cell phone on a Seagate 2 terabyte external USB drive.
Nightmare fuel every time I hear that. Seagate 2 terabyte external
That's
drive.
what we were talking about. Well, it's not 64 terabytes.
It's not as many. It's still decently big.
This is only 1/32 of the 64 terabytes. See, I'm not that bad. Okay, so he downloaded the contents of the cell phone. I think they mean to say there. He downloaded or extracted the contents of the cell phone onto one of these Seagate 2 terabyte external USB drives with the XYZ serial number labeled Philadelphia RCFL evidence. Okay. Here and after the USB drive. Okay. On January 9th of 2023, Detective Lawrence Mowry of the Moscow Police Department requested a warrant to search the contents of the USB drive at that time stored at the forensics lab of the Moscow Police Department, Exhibit A. The affidavit for the warrant was signed by Detective Mowry. However, most of the information in the warrant was cut and pasted from an affidavit originally bearing the signature of Moscow Police Department Sergeant Blaker. But according to Mowry, now the sworn statement of Corporal Payne. So wait a minute, who signed the affidavit?
Just everybody, just little copy paste from everyone. A signature here, a signature there. Just control, take the control less, take a screenshot, move it over.
But wait a minute, an affidavit at the very bottom has to state these are my own personal observations or based on information known to me.
Are you trying to say you don't have the exact same experience as someone else?
What I'm trying to say is when you sign an affidavit, it is your personal observations or information that you know to be credible. I can't have a blank affidavit and sign it and then give you the same blank affidavit and have you sign it because those are my
just have everybody write their own stories.
Yeah, I mean, unless you're, my observations and your observations are two different things. So what they're saying here is that the affidavit for the warrant was signed by Detective Mowry, but most of the information in the warrant was cut and pasted from an affidavit that had originally borne the signature of Sergeant Blaker, But now, according to Mowry, now the sworn statement of Corporal Payne.
It's everybody. Okay.
The basic facts Mowry used to support the search warrant were those used to arrest Mr. Kohberger and are the subject of a Frank's motion. Additional facts related to the cell phone data are as follows. The phone was seized when Mr. Kohberger's house in Pennsylvania was searched. Okay. Data on the phone had already been extracted by the FBI. Who's on first here? The search warrant for Mr. Kohberger's family home in Pennsylvania is also the subject of a motion to suppress. If the search of the house is suppressed, that will be an additional ground to suppress the phone. So here's their argument. The affidavit submitted in support of the application for the issued search warrant recklessly or intentionally omitted material information. The Fourth Amendment states unambiguously that no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. That's basic constitutional law that goes far before that 2004 case.
I was going to say that's a nice recent case that they got for that.
Yeah. Well, these basic concepts that go all the way back to the founding of our country, are frequently, revisited and restated by the court, and that's what happened here. And they go into the validity of a probable cause, the validity of a search warrant, and we've gone over all of this before. I think most of our viewers understand all this. What Mr. Kohberger's attorneys are saying here is that information gathered about Mr. Kohberger via previous invalid warrants must be eliminated. The information gathered via the various other warrants are argued in motions to suppress, and any applicable information should be excised, taken out of there for the reasons argued. The search warrant fails to command law enforcement to search the USB drive. The warrant in this matter fails to actually provide a command to search the USB drive. It states in summary, there are grounds for issuing a search warrant. There are grounds to believe the USB drive for evidence regarding the investigation, including, and then lists all possibly types of data on the drive located in the MPD's forensic lab. I'm not going to point out the grammatical errors there, but the command is made to search the premises defined as the police station's forensic lab for the property and seize it. The court relied on these findings to dismiss a post-conviction claim, finding the defendant would not have been successful had he challenged the fact that the computer searched was omitted from items to be searched in the command. So is this a fine point? Maybe. But it's an important point that rises to Fourth Amendment issues that the search warrant was not complete. The search warrant did not itemize that particular drive. And Jay Logston, who signed this objection or motion, says, Mr. Kohberger requests this court suppress all evidence obtained by police via the search of the copy of his cell phone created by the FBI. As explained above, the warrant used lacked probable cause as written, given its heavy reliance on conclusions reached by law enforcement without the details necessary for the magistrate to draw his own conclusions. Because the warrant omitted exculpatory information and information that put into question the reliability of the facts upon which it relies, because the affidavit relied on evidence gained in violation of the Constitution. And the warrant lacked particularity as to what to be searched, and the warrant failed to command the police to search the drive, all in violation of the Fourth Amendment. So that is his argument. And some will say, well, it's a minor point. Well, he mentioned the police station. You could just deduce that it was, but no, again, in a capital punishment case where the DP is on the table, you would think that police would pay a little bit more attention and not write motions that have two twos and that just have affidavits that are kind of cut and pasted and not specific to the person who is signing it. So it just seems like sloppy police work all the way around.
I'm interested in seeing what our commenters are going to say, because I imagine that there's going to be a number of people that are going to feel, well, I don't understand like why they're trying to hide this phone. Like, if someone's on trial for committing a crime, shouldn't everything they have be seized? And I think because that was one of my first things, so it's just like, take all their stuff or whatever. But, you're just standing accused. Nobody's found guilty or not guilty yet. So I think, they do have a point in saying like you didn't actually have the permissions you needed to properly search this thing. So I'm curious to see you watching this right now. Like, what do you think? Do you think that they do have a right to just search all of that stuff, regardless of the Constitution or anything, considering the circumstances? Or do you think that this is more of the right thing to do where they didn't have the proper, foundation to be doing this?
Or don't you think in a case in which, you're going for the ultimate penalty, what could be worse than capital punishment? What could be worse? They're not just, slapping his wrist and giving him a fine. They're not just sending him down to the local detention center for a year. They're not just sending him to the big house for, 10 years. It's not even a matter of sending him away for life. They're talking about capital punishment, and they're very firm about this. Despite, a dozen motions to take it off the table, the judge was very firm on saying, no, capital punishment is on the table. But don't you think in a case like this, you would dot your I's and cross your T's? Let me give you a stupid analogy, all right? Let me give you a stupid analogy. When I was a kid, I was into model rocketry. There was a model rocket club in my junior high school, and we would stay after school and build under the watchful eye of our advisor, by the way, or a couple of advisors. We would build these model rockets, and we would have engines. Certain rockets had smaller engines, and bigger rockets had big engines. We'd light the fuse, boom, it went up, and we'd laugh or we'd cry, whatever, depending on what happened. There's a big difference between the watchful eye of our advisor in that case or sending a computerized device with 7 human lives to Mars. I mean, that's the difference. This isn't some local yokel little case where somebody, ran a stop sign, and should we fine him $500 or not? This is a capital murder case. And don't you think that the taxpayers and, God forbid, the victims deserve more than this? Don't you think they deserve a higher quality? Now, I admit that was a stupid analogy, but that's all that came to mind at the moment.
Oh, it's just like, I think you have a great point where, like, me as a student, when I'm developing software, if there's a single typo, it's not gonna run.
That's right.
I can't even run that. So in a situation like this, it's infinitely more serious than anything that I'm doing. And why am I getting penalized harder when I go on class and I do a presentation and any minor thing is completely roasted? To see the 1, 2, 2, 3, 4, and we make our mistakes on this podcast, but we're not on a capital punishment trial. I think you make a great point.
And just to emphasize how serious this case is, again, it's, we can't be making little mistakes. We can't apologize for people that make little mistakes. They might call as many as 2,500 people to question whether or not they should be on the jury. Now, if you've seen this article before, you're not surprised by that. But I was surprised. Ada County, Idaho prepares for another Brian Kohberger's high-profile trial. This got by most of us because it was published the day after Christmas. It was published December 26th of 2024. And this is Ada County, Idaho. First the Lori Vallow trial, then her husband Chad Daybell's trial, and now the Ada County Courthouse in Boise, Idaho is getting ready for all eyes to be back on them as the trial for Brian Kohberger is scheduled to start in August 13th to be exact. Goes into some background. While we are still months away from the start of that trial, the courthouse is already gearing up for it. This, as people all over the world are waiting and will no doubt be watching. Every time we have handled one of these types of large trials, obviously, you take away a number of things from it. Deputy Administrative Judge James Cawthorn said, it certainly is in quick succession. Regardless, he said, the focus is always the same. to ensure that people's constitutional rights are protected and ensured. Now, okay, this is nice for a local newspaper. They're saying, our local courthouse has had these two huge trials before, Chad Daybell and Lori Vallow, but, so we can handle Kohberger. And he goes on to talk about the game plan and all this kind of stuff. But this is what caught my attention in this article. The number of potential jurors summoned will be up to the presiding judge, Judge Stephen Hippler. For context, about 1,800 potential jurors were summoned for the Lori Vallow trial, and some 2,500 potential jurors were summoned for Chad Daybell's. I would say that's what I would call a good ballpark number, but I would not hazard a guess as to what size the pool would end up being, Cawthorn said. So I found that amazing. I guess I missed that in the Chad Daybell trial, that they called a potential veneer of 2,500 people out of the community. That's a lot of people.
Yeah, especially when you're talking about these more remote locations. I mean, finding that group of people in New York, California, Chicago. I don't know.
Well, this is Boise. So it's not Moscow. Moscow was a little town with a population, if I remember correctly, of around, don't yell at me because I'm guessing from my memory, about 35,000 people. So Moscow was a small town. Boise, obviously, I don't know the population of Boise off the top of my head, but just seemed to me 2,500 people. I mean, I go to court all the time, and there's a jury room with a bunch of people sitting there waiting. And I know that in the federal court that I went, because I was called for jury duty, it was a big room, but there are no 2,500 people. I would guess there might have been 100 people in the room. And they had 3 trials going on that day. But physically, I mean, as that judge said, they are accustomed to it from the Chad Daybell and Lori Vallow trials. But how do you fit 2,500 people even in a room?
Mm-hmm. Well, my thought is that I'm assuming going back a few months, if not a year at this point, they're expecting a lot of people to fail their magic question that we made a video on a while back.
The magic question.
You go in, they ask the magic question, you fail, get out. That must be it.
Yeah, well, the prosecution's motion was to not ask the magic question, to be a little bit more thorough and, tapping into people's, minds. Not only have you ever read anything or seen anything or heard anything, but despite the fact that you read anything or saw anything or heard anything, what are your impressions? Not, can you be fair? Oh, you can't? Okay, get out of here. I mean, that'd be too easy for people to either get on or off the jury. So the idea there was to ask more penetrating questions. And the American Bar Association actually had a great article that we just kind of summarized on how to ask those questions, what questions to ask, what context to ask them. But anyway, to go through that much beyond the magic question with 2,500 people, that's going to take forever. But
I can't imagine that. I'm glad I don't have to be the person interviewing them. What this is teaching me is that I got to become a lot more biased and discriminatory, so that way they don't select me in these court cases, because I'd be way too neutral.
Well, you represent half of the people, and we'll ask our commenters, which half of the people are you with? Half of the people are like you. They don't want to be bothered. You have a life. You have all the things that you need to do in your life, and you don't want to go outside of that. And a lot of people are like that. The other half of the people are like, I want to be on the jury. I want to, if not just for personal interest or because you're retired or you have the type of a job where you can take off out of personal interest, but maybe I can write a book.
You know what? Fair. Maybe I'm just not an entrepreneur enough.
Like I've mentioned this before, but I'll mention it again. Within days after the Murdoch trial, 3 of the jurors were sitting on panel on Good Morning America. So you can go and be famous. Not that a lot of people don't want that fame. A lot of people would just as rather go on with their own. So let's ask our commenters. Would you want to be on the jury either out of interest or to use it somehow, or would you rather just go on with your life and not be bothered?
Now, speaking of the commenters, Andrew, I was going to ask, do you have anything else you wanted to review today, or should we dive straight into the comments today?
Oh, I think we've done enough.
All right. So I will let you take over this comment from Amy Butler.
Oh, okay. Amy Butler, 2772. Y'all, I love when people say y'all. Y'all probably will not see this. Well, look, we did.
Here we are.
However, I'm a longtime watcher. Thank you, Amy. I have had the same thoughts about the Manson walls. In my teens, I was a big partier, and the things on our party house walls would make a sailor blush in shame, as it does me thinking about it now. Amy, what did you write on those walls? This goes to the comment I made last week. You know how the law enforcement before 1122 King Road was demolished, which we're looking at now in the lower right-hand corner. Law enforcement cut out a portion of the wall, sealed it off so people couldn't see, and removed it. And I said, I don't think anybody really knows what was on that wall, whether it was just blood spatter or something like in the Charles Manson case, where the Manson family, while they were doing their horrible crimes, wrote awful things, kind of along the lines of Proctor. They wrote awful things on the walls, and, photographs were taken, and the photographs were shown to the jury. So that's where that comment comes from. And it's like, yeah,
there has to be a reason to take it. I have to say, I agree with you in that department.
Yeah.
All right.
Okay. So then, we both pushed the button at the same time. All right. Go.
We're on the same wavelength. Harold Head 7555. I have no idea if BK is guilty or not. I do know that there are far more compelling likelihood of who and why these young people were brutally aimed. There is massive criminal gang cartel D and possible human trafficking in that area. D party house. Yeah. It's so, I mean, 1.5 million reasons why something can happen, even though, I know everybody has their different theories, but there's also cases where people just find random people and make victims. It's hard to say what could have been the reasonings.
Yeah, the picture in the lower right-hand corner of that slide was taken from one of the 3 times in the months prior to November 13th of 2022, when law enforcement was called to that premises at 1122 on noise complaints. And so, Harold Head is not alone in thinking that the fact that it was a party house had something to, it's just not a good thing to have so many people in and out of you.
Yeah.
I know people will disagree with me. Go ahead. Okay. Kaylee 86B616 says, there's something that most people aren't considering when it comes to the alleged touch DNA on the knife sheath. It doesn't necessarily have to be that someone had a sample of BK's DNA and planted it on there. It could just be that it's not even a match to begin with. Well, that's probably why Ann Taylor and her crew are fighting to get the procedure that law enforcement went through to get the genetic genealogy data. That is a source of contention. We've been through it so many times, I don't think we need to talk about it again. But the touch DNA initial sample was so tiny that they had to enlarge it, duplicate it before they went down that road. And I think we've gone down that road enough in previous episodes.
Stephen Price, 6957. This bloke is guilty as Karen Reed. Both are cooked. And at Kelly Dumpede, Free Brian Kohberger, an innocent man. Oh, so these are 2 different commenters from Kelly and Stephen. And I think this really just highlights what our we talk about this all the time, how half of our comments are saying one thing, half our comments are saying the other, half of our comments are accusing of us being biased towards one person and us being biased towards the other. So there's no escaping the polarizing nature of this.
Yeah, that's very typical. And people don't just say what they think. He is guilty as both are cooked, or free Brian Kohberger. People are very, and these were polite comments, and we thank people for being polite and not using all kinds of language. Oh my gosh, when I go into the blocked comments. What do they call that? I go up to
Just
the top.
removed, censored.
Yeah,
type.
the ones that were removed. We don't remove them, folks. YT does it. They call each other names. There's no need for that. These two people expressed themselves. They were pithy. I love that word. They were short. They were brief. They were concise, to the point. We see what they said, and they didn't have to say, you're this or that if you don't agree with me. Okay, our final comment for the day. Andrew, does it seem to you, being an attorney, that the state is dilly-dallying because they don't have much of a case? I know that none of us know for sure, but that sure seems like what is happening. If you ask me, in so many instances, they could just simply hand over evidence, produce documents for their witnesses, etc. But instead, they play word salad and drag these issues on and on by just producing what is needed. Well, that breaks down really into two questions. No, I don't think that they're dilly-dallying. I mean, remember that the prosecution in this case was ready for trial a long time ago. They were ready for trial initially. Before Brian Kohberger waived his right to speedy trial, they had been ready for trial, and they were then a second time, even after he waived that right. Remember that they wanted to try it starting in June of 2024.
Mm-hmm.
I don't think that they're dragging their feet. I do think that they're engaging in word salad. We covered the motion where there were specific questions that were asked. Hey, you notified us of 25 experts, but you only gave the supporting material on 5 of them. Then the state's response was, oh, well, look, in the Franks motion, we gave you 500 or 200 pages. No, that doesn't answer the question. That's like a little kid. It's like, did you eat the candy in the cookie jar? I did my homework. So, and then the other side of that is that, they are not giving their due diligence, in my view, of providing information that's responsive. But I don't think that is going to delay things, because Judge Hippler has said, among other things, that he expects people to adhere to rules and schedules. And after a lengthy hearing, asking both sides what they wanted, he set down jury selection to start in July of 2025 and the trial to start on August 11th. So in my view, I think that he will require them to comply with that schedule. That said, we always have to point out that, and we get a hard time all the time for sometimes making light, but we have to remember that this case is about the 4 who lost their lives on November 13th of 2022. Kaylee Gonsalves, Madison Mogan, Ethan Chapin, and Xana Kernodle, and there they are. And we do just need to point that out in every episode, that that's what this whole case is about. And we do certainly hope that there is justice, not only for their families, but for everyone. I mean, if you live in a community and something as awful as this happens, it's got to be shocking. I really could care less about Scott Green. I could care less about the University of Idaho. Lambaste me all you want in the comments, but you've got to feel for these families of these 4, and so that's why we make sure that we mention it in every episode. So, yeah, that's my closing thought. What's yours?
No, similar to as it always is. This is a complicated case, so we appreciate you guys making it to the end, and hopefully we were able to demystify some of the aspects of this for you. And we just appreciate your support. We appreciate your comments. They always make my day, so thank you guys so much.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.